eligibility for the National Assembly is of public importance. The general public needs to know if candidates on a party list are eligible to be members of the National Assembly. In respect of the merits, this court finds that the purpose of the disqualification in section 47(1)(e) is aimed at maintaining the integrity of South Africa's democratic regime, which is founded on the rule of law, by ensuring that members of the National Assembly possess the requisite respect for the rule of law. This court finds that the purpose of the proviso is to allow the appeal process to unfold. It is aimed at ensuring that a person is only disqualified from standing for and holding office once their conviction and sentence are final. It does not prevent a sentence that is final and immune from appeal from being a sentence for the purpose of section 47(1)(e). The reasoning of the Electoral Court in finding that the sentence that was imposed on Mr. Zuma could not be said to be a sentence which the section contemplates cannot be sustained. This is because it has no support in the text of section 47(1)(e). Section 47(1)(e) applies to anyone who has been sentenced to more than 12 months imprisonment. The text does not qualify the words sentence and sentenced to exclude sentences imposed by this court. The Electoral Court's judgment and the respondent's contentions are tantamount to equating until in section 47(1)(e) to unless. The interpretation of section 47(1)(e) of the Constitution adopted by the Electoral Court subverts the purpose to be achieved by the section. In relation to the legal effect of a remission of sentence, this court finds that section 47(1)(e) focuses on the length of the sentence imposed, not the length of sentence served. The section uses the words convicted of an offence and sentenced. The effect of a remission of sentence is to bring forward a person's date of release. Remission of sentence concerns the execution of the sentence and does not retrospectively alter the sentence imposed by a court. Thus, for purposes of section 47(1)(e), remission of sentence is irrelevant. In respect of whether the Commission exceeded its powers, this court considered the relevant provisions of the Electoral Act. Section 30, sub 3 of the Electoral Act requires the Commission to decide the objection, while section 27 of the Electoral Act deals with a party's list of candidates. Section 27(2)(b) requires that lists must be accompanied by a prescribed declaration from a representative of the party, and I quote, that each candidate on the list is qualified to stand for election in terms of the Constitution, close quotes. The form for a candidate list is prescribed in Appendix 1 to the regulations concerning the submission of lists of candidates, 2004. It requires that a party's list must include an undertaking from a party representative that, and I quote, each candidate on the list is qualified to stand for election in terms of section 47 of the Constitution, close quotes. The court finds that in terms of these provisions of the Electoral Act, the Commission is empowered to determine before the election qualification for membership of the National Assembly. In relation to the question of bias on the part of Commissioner Love and or the Commission, the respondents submit that there is a reasonable apprehension of bias on the part of the Commission to the extent that the Commission as a whole was legally excluded from deciding the question of Mr. Zuma's eligibility to stand as a candidate in the elections. They rely on a statement made by Commissioner Love to the media in relation to Mr. Zuma's eligibility to stand as a candidate in the election. Commissioner Love was quoted to have made the following statement on 24 January 2024 at a press briefing when a question was specifically asked about Mr. Zuma's eligibility to stand as a candidate. And this is what she said. That excludes anybody who has been given a sentence that was not subject of any deferral, and in that sense, it is not ourselves, but the laws of the country that would stand as an impediment for that candidacy, close quotes. This court finds that the Electoral Court correctly found that the context in which Commissioner Love was speaking for the Commission was ambiguous and without specificity. In respect of the question whether Mr. Zuma was convicted as contemplated in Section 47(1), this court finds that there is no difference between a conviction following criminal proceedings and a conviction following civil contempt of court proceedings, since a person is convicted of a criminal offence in respect of both proceedings. Section 47(1)(e) draws no distinction between convictions for civil contempt and other convictions. Therefore, the ordinary meaning of an offence should be given to the word, that it is a criminal offence. It is not for a court to limit the scope of the provision. The section clearly says, convicted of an offence and sentenced to more than 12 months imprisonment without the option of a fine. Mr. Zuma was convicted in that this court found him guilty of the crime of contempt of court. This court concludes that Mr. Zuma was convicted of an offence and sentenced to more than 12 months imprisonment for the purposes of Section 47(1)(e) of the Constitution, and is accordingly not eligible to be a member of and not qualified to stand for election to the National Assembly until 5 years have elapsed since the completion of his sentence. In the result, the following order is made. The applicant is granted leave to appeal directly to this court. It is declared that Mr. Zuma was convicted of an offence and sentenced to more than 12-month imprisonment for purposes of Section 47(1)(e) of the Constitution, and is accordingly not eligible to be a member of and not qualified to stand for election to the National Assembly until 5 years have elapsed since the completion of his sentence. The order of the Electoral Court is set aside and replaced with the following, and I quote, "The appeal is dismissed," close quotes. The counter-application is dismissed. There is no order as to costs in this court. I hand down the judgment.
Court adjourned.